Okay guys, this is lesson 6, the second lesson on equality. We are now at the lesson of the 21st of August. In the electronic class, remember that the work you will be doing, that you will be writing test about, will be number 4, limitation of rights, number 5, equality 1, and then again number 5, equality 2. Okay, so we're starting on page 222, discrimination and unfair discrimination. Now, discrimination is a particular form of differentiation. It's a differentiation on illegitimate grounds. Remember, we spoke about mere differentiation in the previous lesson, which would not be unfair discrimination. But when we differentiate on illegitimate grounds, then we have discrimination. Now, there are a list of grounds found in section 9.3 of the Constitution and analogous grounds to those listed in 9.3 that would all constitute discrimination. Now, this is discrimination or differentiation based on attributes or characteristics which has the potential to impair the fundamental dignity of a person as a human being or to affect them seriously in a comparably serious manner. Now, discrimination is not prohibited, only unfair discrimination. And that's the important thing to remember. The law can discriminate. There is legitimate grounds on which we can discriminate. For example, a law that differentiates between black and white people places a burden on one group and not the other. Is differentiation on the illegitimate ground of race and therefore discrimination. However, a further qualification is required. The Equality Clause does not prohibit discrimination, it prohibits unfair discrimination. The important implication of this is not all discrimination will be seen as unfair. Fairness is a moral concept that distinguishes legitimate from illegitimate discrimination. Now the question is, what makes it unfair? Now the court has told us that unfair discrimination principally means treating people differently in a way that impairs their fundamental dignity as human beings who are inherently equal in dignity. The concept of dignity is thus of central importance to understanding unfair discrimination. Unfair discrimination is differential treatment that is hurtful or demeaning. It occurs when a law or conduct for no reason treats some people inferior or incapable or less deserving of respect than others. It also occurs when laws or conduct perpetuates or does nothing to remedy existing disadvantage or marginalization. So as soon as we discriminate without a rational connection between the discrimination and the purpose we're trying to achieve, it will be unfair discrimination. Okay. In the previous slide, we were talking about unfair impact, and that's a way to determine whether discrimination is unfair, is the impact that it has on the person against whom it's being discriminated. Now, the concept of unfair impact was discussed in the Harkson case, and it is actually called the Harkson test now. So the Constitutional Court gave us 3 factors that must be taken into account when determining whether discrimination has an unfair impact. Number 1, the position of the complainants in society and whether they have been victims of past patterns of discrimination. Differential treatment that burdens people in a disadvantaged position is more likely to be unfair than burdens placed on those who are relatively well off. Now, the idea of this, for example, is the fact that we have affirmative action, or there are students when they decide who gets into a specific program at tertiary education, for example, medicine, there is a system in which certain races has to be, will get accepted into a program, a larger proportion of a certain race. This is to reflect the demographic, but also to address disadvantages of the past. So if right now Africans have a bigger chance of getting into, for example, a medicine program at a university. If this was turned around and suddenly they said white males will get preference above all other races, this will be unfair because it places a burden on disadvantaged people, people that have experienced past patterns of discrimination. Now the second one, the nature of the discriminating law or action and the purpose sought to be achieved by it. An important consideration would be whether the primary purpose of the law or action is to achieve a worthy and important societal goal. Now that speaks for itself. When there is any differentiation or discrimination, it has to be for a worthy and important societal goal. It shouldn't be a goal just for one group of people or a goal just for Parliament. It should be a societal goal. So the general society of South Africa should benefit from this discrimination. Now, number 3, the extent to which the rights of the complainant have been impaired and whether there has been an impairment of his or her fundamental dignity. Even taking these other two into account, you cannot impair a right if it's going to impair the fundamental dignity of certain people. So even if it is for society's welfare, you cannot do something that infringes on the basic right of dignity of a person. These 3 things will determine whether there has in fact been an unfair impact. Now we'll move on to section D on page 224, which is fair discrimination. Now it seems puzzling that not all discrimination is unfair, and that there could be such a thing as fair discrimination. This is because in everyday speech, the word discrimination carries pejorative associations. Most people would say that it is wrong to discriminate and would be hard-pressed to understand someone who said that sometimes the discrimination is not wrong, or that only unfair discrimination is wrong. In our society, the word discrimination is such a loaded word that it's difficult to think that you could fairly discriminate against someone. Now, a very important case for you to discuss if I ask you fair discrimination is the case of President of the Republic of South Africa versus Hugo. Now, this case perfectly illustrates fair discrimination versus unfair discrimination. We have already done this case in previous lessons. When Nelson Mandela was president, he granted a remission of sentence to all mothers who were in prison at the time and who had children under the age of 12 years. So he said, I will pardon you. If you have a child below the age of 12 years and you're a female in prison, you will be pardoned. Now, the respondent was a prisoner who was a father of a child under 12 years, and he argued that the president's order unfairly discriminated against him on the basis of gender. And the court found that the president's act constituted discrimination on 2 grounds. It was discrimination based on sex, coupled with parenthood of children below the age of 12. The first of these was a listed ground in section 9, 6. Well, at that time it was the interim constitution, so it would be section 8. But this means that the act should be considered unfair discrimination unless the contrary is proved. So if you just look at the fact that he was discriminating based on sex, females getting preference above males, it would be unfair discrimination. But now the contrary needed to be proved. And after considering all the facts, the majority of the court treated it as an acceptable generalization that in South African society, mothers are primarily responsible for nurturing and rearing children. This imposes a tremendous burden on women and is one of the root causes of women's inequality in society. And if on the basis of this generalization, the president had denied an opportunity to mothers that he had afforded to fathers, his actions would have been unfair discrimination. So if the discrimination happened to the other side, if he said all fathers of children below 12 would be released, that would be unfair. Because women having to take care of children in South Africa is a tremendous burden on them and is a root cause of women's inequality. So they are a previously disadvantaged group. Women are disadvantaged against men in all races. However, the president did the opposite. On the basis of this generalization, he afforded an opportunity to mothers which he denied to fathers. Though this was discrimination, it was not unfair. The decision of the president benefited children and gave women prisoners with minor children an advantage. So, regarding men, all the act was doing was depriving fathers of minor children of an early release, which they in any way were not legally entitled to. There were also a far larger number of fathers imprisoned than mothers. So the release of such a large number of prisoners would have led public outcry. Thus, it could not be argued that the decision not to afford male prisoners the same opportunity impaired their sense of dignity as human beings or their sense of equal worth. Being released from prison early is not something you will ever be entitled to. So they can't say that the fact that they have to stay in prison while the females were pardoned had any effect on their dignity. They would have been there in any way. It could be said that the purpose of the President's Act was to achieve a worthy and important societal goal. It was designed to benefit three groups of prisoners, namely disabled prisoners, young people and mothers of young children, and it was an act of mercy. The fact that all these groups were regarded as being particularly vulnerable in society, and that in the case of the disabled and the young mothers, they belonged to groups who had been victims of discrimination in the past, weighed within the court in concluding that the discrimination was not unfair. Discrimination was against the class of individuals, fathers, who had not historically been subjected to a disadvantage, as opposed to mothers. Now, this case is very important. Look on page 224 and 225. Study this case. So the case of Hugo is the case of fair discrimination. You will most probably be asked the question to discuss both fair and unfair discrimination. Then you will have to discuss two cases: for fair discrimination, President of the Republic of South Africa versus Hugo, and for unfair discrimination, the City Council of Pretoria versus Walker. So when discrimination has an unfair impact or imposes burdens on people who have been victims of past matters of discrimination, or where it impairs to a significant extent the fundamental dignity of the complainant, we have unfair discrimination. Now, the case of City Council of Pretoria versus Walker illustrates the idea of unfair discrimination and fair discrimination. In this decision, the court examines the impact of two policies of the Pretoria City Council. Now, this was in the year 1998, so it was fresh in the new democracy. Now, the Pretoria City Council had jurisdiction over three areas: the exclusively old white areas of Old Pretoria. So this is Pretoria as we know it, the suburbs, Old Pretoria. They also had jurisdiction over Attridgeville and then Mamelodi. Now, the residents of Old Pretoria were mainly and exclusively white, whilst Attridgeville and Mamelodi were mostly black. In Old Pretoria, the white population and mostly affluent people, their electricity was based on a consumption rate. So they paid rates based on consumption of water and electricity. The actual consumption that they used were measured by meters placed in each property. The residents of Attridgeville and Mamelodi, remember this is 4 years after the birth of our democracy, they paid a flat rate per household. No matter how much or how little water or electricity they consumed, each family paid a small amount. Now, Mr. Walker, we can say that this is Mr. Walker, resident of Old Pretoria, complained that the flat rate in Mamelodi and Attridgeville was lower than the metered rate. And this meant that the residents of Old Pretoria subsided the townships. So he found, let's say for example, they paid 2 Rand per unit of electricity, and at the end of the month, a normal household of 4 would use 1,000 Rands worth of electricity, and they'd pay 2 Rand per unit they used. The residents of Attridgeville and Mamelodi paid a flat rate of, let's say, 200 Rand, which was a lot less than the white population. And he felt that this was unfair discrimination. Furthermore, he also complained that only residents of Old Pretoria was singled out by the council for legal action to recover arrears owed for services, whilst a policy of non-enforcement was followed in respect of Mamelodi and Atteridgeville. So in Old Pretoria, if you did not pay your electricity, if you failed to pay, they'd switch your electricity off and legal action would be taken against you. In Atteridgeville and Mamelodi, the people simply did not pay and there were no consequences. Now, this case eventually went to the Constitutional Court, and the Constitutional Court had to consider if the actions of the Pretoria City Council was indirect discrimination on the listed ground of race. However, the majority went on to hold that the first set of actions that Walker complained of, which is the flat rate and the cross-subsidiation, was not unfair discrimination, while the second set was unfair. So they found that number 1 was fair discrimination, number 2 was unfair discrimination. Now, unfair discrimination is a differentiation that has an unfair impact on the victims. In this regard, the court first took into account that Walker was white, and therefore he belonged to a group that had not been disadvantaged by the racial policies and practices of the past. In an economic sense, this group was neither disadvantaged nor vulnerable, having benefited rather than been adversely affected by discrimination in the past. So, what was the purpose of the council's actions? The council's decision to confine the flat rate to Atteridgeville and Mamelodi and to continue charging the metered rate in Old Pretoria was dictated by circumstances. First, the council inherited a situation in which the townships were not equipped with metering equipment, while houses in Pretoria were. Remember, during the apartheid years, the rural areas, or the townships, they did not have access to electricity. Only the white areas did. So what the Pretoria City Council had were 2 very big townships who did not have meters for their electricity. And Old Pretoria's wealthier and more developed area than Atteridgeville and Mamelodi. It was a fair assumption that Old Pretoria would have accounted for a major proportion of the total consumption of water and electricity in the municipality. So Old Pretoria, these people had swimming pools and televisions and fridges and microwaves and computers and radios and all the electronic equipment. So they were obviously using a very large proportion of the electricity, while the residents of Atteridgeville and Mamelodi only got electricity a couple of years ago, and they were still living in the shacks. So what kind of electricity how much electricity could they actually be using? They're a very big group of people, so in total it would be a lot. But individual households, you couldn't possibly compare their usage to that of a normal household in suburban Pretoria. To have applied a flat rate throughout the entire municipality would have been unscientific and would have resulted in far greater prejudice to the individual users of Atteridgeville and Mamelodi alone. So if they decided that both Old Pretoria and Atteridgeville and Mamelodi would pay the same flat rate each month, it would be unfair because they did not use as much electricity and they were not as affluent. In these circumstances, the adoption of a flat rate as an interim arrangement while meters were being installed in the residential areas of the townships was the only practical solution. The City Council was not planning to keep this situation indefinitely. It was just until Atteridgeville and Mamelodi could install meters into their houses so that they could see the actual usage of each family and they would then pay that. Now, the second one, the cross-subsidiation. The Constitutional Court held that the levying of different rates for the same service is not always unfair. The cross-subsidiation in this case was temporary and would be phased out once meters had been installed in the townships, and a consumption-based tariff was introduced. In the meantime, the fact that the white town subsided consumption in the black township could not be said to impact adversely on the respondent in any material way. There was no invasion of the respondent's dignity, nor was he affected in a manner comparably serious to invasion of his dignity. He wasn't paying more for his electricity. He was just paying a rate that stayed the same whilst they were paying a lower rate. Now, the last thing was the selective recovery of outstanding service charges. So the fact that the residents of Old Pretoria were singled out for legal action, while the residents of the townships knew they would not get any legal action. In Old Pretoria, a lot of residents, such as Walker, were summoned and service were suspended in their houses. In the townships, there were no suspension or any legal against the defaulters. According to the court, the council had set in place a properly formulated policy directed at achieving the important societal goal of transforming both the living condition and culture of non-payment of service charges in the township, the policy might well have been consistent with the goal of furthering equality for all. It would therefore have been a measure aimed at achieving substantive or restitutionary equality and not in conflict with the equality right. Instead, the policy of taking no legal action to enforce payments of arrears had nothing to do with the ability of residents to pay, or the introduction of meter charges, and was applicable to all residents of Atteridgeville and Mamelodi. So what the court was saying was the fact that they were only asking the residents of Old Pretoria, taking legal action against them, was unfair. Because it wasn't based on whether you could pay or not. Because they never tested if people in Atteridgeville and Mamelodi could pay. They just decided that irrespective of your income, if you lived in this area, you would not have to pay. Or your services would not be suspended and there would be no legal action. So in these circumstances, the council had not discharged the burden of showing that racial discrimination was not unfair. So in the case of City Council versus Pretoria versus Walker, 2 grounds of discrimination, 1 to be found fair, the second to be found unfair. Important that you are able to discuss. Okay. Now we move on to the 3rd grounds against you on which you cannot discriminate, namely sexual orientation. Now this ground is an important ground for test and exam purposes, so be able to discuss this as a longer question. Okay, now we're going to start with decriminalization of sexual orientation. Now today, our society is mostly very tolerant and accepted of homosexuals, either gay or lesbian. But there was a time in South African history where any homosexual act was considered to be a criminal act. This was premised on moral disapproval and the common law offense of sodomy and related statutory offenses. So if it could be proved that 2 men were in a homosexual relationship, they would be arrested and they'd be accused of a criminal act, the criminal act of sodomy. Now, obviously, this was in conflict with the right against sexual orientated discrimination in the New South Africa. The ground was accordingly the basis for the invalidation of the common law offense of sodomy. Now, the case that this was heard on was the case of the National Coalition of Gay and Lesbian Equality versus Minister of Home Affairs. In this case, the court defined the term by reference to erotic attraction to members of the opposite sex, and in the case of gay and lesbians to members of the same sex. And it was not a reference to a lifestyle choice. Now, this quote here is what was actually said at court. Now, it starts with the concept of sexual orientation as used in section 9.3. So what the court here did was firstly explain the idea of sexual orientation. It must be given a generous interpretation, of which it's linguistically and textually fully capable of bearing. It applies equally to the orientation of a person who is bisexual, transsexual, and also applies to the orientation of people who might, on a single occasion, only be erotically attracted to a member of their own sex. So if I ask you in a test, what does sexual orientation mean in terms of section 9.3, you need to tell me that it refers to people bisexual, transsexual, and even people who only on a single occasion might experiment with someone of their own sex. The discriminatory prohibitions on sex between men reinforces already existing societal prejudice and severely increases the negative effects of such prejudice on their lives. But such provisions only impinge peripherally in other harmful ways on gay men, which go beyond the immediate impact on their dignity and self-esteem. Their consequences, legitimate or encouraged blackmail, police entrapment, violence, and discrimination, such as refusal of facilities, accommodation, and opportunities. The impact of discrimination on gays and lesbians is rendered more serious, and their vulnerability increased by the fact that they are a political minority, not able on their own to use political power to secure favorable legislation for themselves. So here the court explained what sexual orientation is. It refers to heterosexual relationships, homosexual relationships, transsexual, bisexual, and even people that just experiment. And the fact that we have laws discriminating against sexual acts between males, as sodomy is a sexual act between two gay men, infringes on their lives. And except for the fact that it has an impact on their dignity and self-esteem, it also has consequences of blackmail, police entrapment, etc. Now, according to the court, the sexual orientation provision protects an identifiable group, those people erotically attracted to members of the same sex. The rationale for this identification, the singling out of a group of people for constitutional protection, is a common experience of humiliating domination, stigmatization, and prejudice. So the Constitutional Court explicitly referred to gays and lesbians because they are a group of people that need to be protected. Now, provisions of the now repealed legislation include the following. In the legislation, the consent for sexual intercourse between heterosexuals, between a man and a woman, was 16 years, for example, and for homosexuals, it was 18 years. Now, the problem with that, according to the court, was that these sections creates the idea that there's something odd, deviant, or even perverse about homosexual acts and or homosexual peoples. And due to that, the act was then. So concerning sexual orientation, the first thing was decriminalization of the homosexual erotic acts. The next big thing that happened was the exclusion of persons in same-sex relationships from benefits according to married people. Remember that you couldn't legally get married if you were homosexual in South Africa. That would mean that if we have two women that have been in a relationship for 30 years, two homosexual women, two lesbian women, and they've been happily living together, they're beneficiaries of each other's wills and estates, they've been together, they have had a healthy, happy relationship, and one of them dies. Let's say they die and then they find the wills are missing or there are no wills. Usually, if it was a man and a woman living together for 25 years, the woman would still get the benefit of a married woman. Married people, if they die interstate, the wife or the husband gets the estate. Gay and lesbians could not marry, so they were not accorded the benefits that married people were. So in the case of National Coalition for Gay and Lesbian Equality versus Minister of Home Affairs, they found that in essence, people in gay and lesbian relationships were being discriminated against. Now this specific example, the specific case, there was a man and a woman. If a man and a woman was married, and the man was a South African citizen and the woman was not, the woman would get a residency permit based on the fact that she was married to the man. Now, the problem with that was people in same-sex relationships was not afforded that same benefit. This differentiation the Constitutional Court held overlapped and intersected on two grounds listed in Section 9.3. One is sexual orientation. It was the discrimination based on sexual orientation, but also on marital status. The purpose of granting this permit to somebody in a marriage was to promote and protect conventional conception of family life. By excluding gay and lesbian couples from this benefit, the legislation was in fact saying that homosexual partners did not constitute a married life. This perpetuated a number of harmful and hurtful stereotypes about gays and lesbians. The first of these stereotypes is that gays and lesbians and their marriage is exclusively sexual, with few or none of the family-orientated characteristics of a heterosexual marriage. The second stereotype is that gay and lesbian relationships do not qualify as family life because they are incapable of procreating. And this is also demeaning not only for homosexual couples, but it's demeaning for couples who cannot have a man and a wife that cannot have children. So the message given out by the legislation, according to the court, was clear. There's a message that gay and lesbians lack the inherent humanity to have their families and their family lives in a same-sex relationship respected or protected. It serves in addition to perpetuate and reinforce existing prejudice and stereotypes. The impact constitutes a gross, blunt, cruel, and serious invasion of their dignity. The discrimination based on sexual orientation is severe because no concern, let alone anything approaching equal concern, is shown for the particular sexual orientation of gays and lesbians. Now, the last thing you need to be able to discuss regarding sexual orientation is the exclusion of persons in same-sex relationships from the institution of marriage. Now, the principle that can be deduced from the decisions listed in A and B is that in general, to provide a benefit to a married person is unfair discrimination on grounds of sexual orientation, since the background of common law confines the status of marriage to heterosexual relationships. So in the case of Fourie versus Minister of Home Affairs, the definition of marriage as a union between a man and a woman was challenged by the Court of Appeal. The trouble of marriage, as Judge Mandala said, is that while not everybody may choose to get married, only heterosexual people were ever given that choice. And that is discrimination, because why can only a man and a woman get married, but people that wish to spend the rest of their lives together cannot based on their sexual orientation? So denying them this choice, it's denying them the option of entering in an honorable and profound estate that is adorned with legal and social recognition, and that it is rewarded with many privileges and secured by many automatic obligations. And instead, also, the denial of this opportunity sends a hurtful message of inferiority to gays and lesbians, telling them that not only are their relationships and commitments and loving bonds inferior, but they themselves are inferior. And that they can never be fully part of a community of moral equals that the Constitution promised to create for all. The continuation of the state of unfair discrimination could not be tolerated, and the definition of marriage has to be changed to accommodate the possibility of same-sex marriages. On appeal, this case went on appeal to the Constitutional Court, but the Constitutional Court endorsed most of the reasoning of the Supreme Court. Now, people that were opposed against having people in same-sex relationships get married based their argument on two points. First, they argued that international law requires the centrality of family to society, and the recognition of same-sex marriages would offend, secondly, the religious rights and freedoms in the Constitution. Both these arguments were rejected by the majority of the Constitutional Court. The Constitutional Court held that although international law does recognize the centrality of family to society, it was not constitutive of a privilege, of privileging one form of family, and since same-sex unions were constitutive of the family, their recognition would never breach international law. International law puts family life central to society, but saying that this would be against international law to recognize these types of relationships is not against international law because they don't specifically say that marriage should be a man and a woman. And then secondly, the religious doctrine can never be used as a source for interpreting Constitution. The hallmark of an open and democratic society is its capacity to accommodate and manage differences of intensely held worldviews and lifestyles in a reasonable and a fair manner. In any event, it was noted under the Marriage Act, no religious minister could be compelled to administer marriage if it was inconsistent with their particular views. So even though the Constitutional Court found that yes, the people of same-sex relationships will be included in the definition of marriage, no religious minister or religious leader will ever be forced to conduct a same-sex marriage. And then secondly, the validity of the Marriage Act was attacked, and the Constitutional Court also declared Section 30 of the Marriage Act unconstitutional. It suspended the declaration of invalidity for a period of 12 months, and flowing from that was the Civil Union Act, which then gives a chance for a civil union, very similar to a marriage, that could be entered into by same-sex and heterosexual couples. So The traditional form of marriage is still just for a man and a woman, but we now have legislation that gives all the same benefits to people of same sex, and even heterosexual couples can choose to get married. Okay, now there are 5 other grounds, listed grounds. These grounds you need to go read, and the only thing I would expect of you is to, in 1 or 2 sentences, explain the ground to me. You can find them on page 232 up until page 235 of your textbook. First one is marital status. The second one is age. Third one is disability. Religion, conscious belief, culture, and language. And then birth and social origin. You need to go read this and just be able to define it. Equality is a very big chapter in our textbooks, so I don't want you to know it in detail. You only have to know the first 3 grounds in detail, with sexual orientation being the one you need to know the best. Now, on page 241 to 244, we get affirmative action. Now, taking into account all you have learned about equality and discrimination, you'll now use this knowledge to challenge yourself. I want you to look at this part of the work as self-study. You can expect a question on affirmative action in either the test or the exam. The question you're going to need to answer will be something like this, the following. Why is affirmative action not considered unfair discrimination? You need to be able to answer that for 10 to 15 marks. The full answer is in your textbook. I will not expect of you to know anything that's not in your textbook, but you need to use the whole chapter on equality to understand affirmative action and why we do not consider it unfair discrimination. Now, test 2 will be written on the 28th of August. We will write it at the time that we have class. I will inform you of these changes. I do not know the venues yet, but as soon as I do, I will inform you guys. The scope is these 3 topics, these pages in your textbook. Focus on the works that I did on the slides. Now remember, I am on leave, so I will not be in my office. Don't go sit and wait for me at the office. But I am available via email any time of day. Please do not hesitate to email me. You can either use the CJUA042@gmail.com email address, or you can use my university email address, Lize-Mari.mitchell@ul.ac.za. You're very welcome to email me. You can email me to both, and I will be replying. So any questions you ask, I'm fully available to you guys, especially regarding test questions. If you have a very long question you want to ask me, record yourself on your phone and send me a voice note via email. Then you don't have to type everything out, and I will be able to consult with you electronically. Remember, we start the test strictly at 3 o'clock. I cannot give you extra time if you are late for the test. You need to be seated at 3 o'clock. Remember, I will not be there when you write your test. But other lecturers will be there, and they will be able to communicate with me at any time if you guys have any questions. Okay, so good luck with your work, and focus on the things that I specifically told you in the slides. This is important.